Good afternoon, everyone here in the audience and also connected remotely. Okay, so let's continue. I'm here today for us to talk about cybersecurity incidents and sanctions pursuant to the data protection law. We will be here discussing that with both ends of this context. How to investigate and how to check those incidents. We have today with us Bruno Garcia with the National Authority of Data Protection. He is a computer scientist. He has a law degree from the Federal University of Minas Gerais, and he has a post-graduation from Getúlio Vargas Foundation. Thank you so much for being with us today. Rafaela will be here bringing a different perspective. She who works with the business side and is also mindful of the legal requirements. She works with iFood and she specializes in digital law. She has a post-graduation.
Obrigada. Vou passar a palavra para o Bruno. E quem está assistindo a gente, tanto na modalidade presencial como online,
those who are with us, both in person or remotely, please feel free to send your questions. We will have some time allocated for that in the end. Good afternoon, everyone. I would like to thank ABPI for the invitation to be here. This is a very important opportunity for us to discuss data protection in Brazil. As a representative of the national authority, I am responsible for the regulatory aspects of this topic. So I will be discussing the security incidents and also the first year of our data protection law in effect. The National Authority of Data Protection is a federal agency. It is responsible for data protection surveillance in Brazil. It was established in 2021. It's part of the federal government, and in 2022, it became an independent special federal organization. Unlike other entities, ANPD was established from scratch. So the challenge is very significant to put together all the infrastructure, human resources, everything that is required for our work. And we have three basic mandates, that is regulatory, also surveillance and sanctioning. The data protection law is a comprehensive law that brings all the provisions in this area. There are still several open clauses to be regulated by other decrees. And today we will be discussing two topics: sanctioning and the communication procedures of incidents. We are now with a an open public hearing for the 2023 and 2024 terms, and it is important that all the civil society be engaged in this discussion. Our surveillance and inspection model has been discussed. Its purpose is to check non-conformities and non-compliant behaviors. There are financial penalties, but it is often not enough to prevent such behaviors. So we act in terms of guidelines, monitoring, prevention, and in case there is repeat non-compliances, then it is when we should impose sanctions. We have resources to monitor those actions, and we have jurisdiction, we have the authority to do so. Data treatment is very pervasive, and it's present in most economic industries. This is why we have this challenge of focusing on what is relevant. These instruments are all present in resolution number 1 of the ANPD. The preventive measures include notices and the objective is to lead the actors to conformity without having to take further action. Before we start a sanctioning procedure, we try to explain what is expected from them so that we have an opportunity to correct what's non-compliant and therefore bring better results for society. Administrative sanctions. Section 52 of the LGPD brings several administrative sanctions. It goes from corrective measures when we believe there is some security measures that are required. We also have financial penalties that can go as high as 50 million, but it's limited to 50% of the company's revenues before tax. Our model in LGPD differs from other actions because there's no description of non-conformities. This is something that will be considered when dosing the penalties. The financial penalties can significantly impact the penalties, and they can lead to blocking or deletion of data, something that can prevent the company from operating. When there is no legal hypothesis for data treatment or when there is some negative objective. But those sanctions come after those in the first phase, and we can go as far as banning some treatment activities. Section 53 of the law, and this is something that is often questioned, when the first sanction will be applied, it is provided in Section 53. The methodology of sanctioning is pursuant to Section 53 of the law. Administrative sanctions and other sanctions, they are now subject of a public hearing, which is open until September 15th. And it is of the utmost importance that civil society be engaged, because this is something that will be applied to everyone. And even though we are not applying sanctions now, LGPD came into effect in 2018, and since August 2021, the administrative nonconformities can be sanctioned. There are some procedures that have been suspended, and they are expecting regulations to be established, and then those sanctions will come into force. Now, cybersecurity and the incident communication procedure. Cybersecurity is a technical field that is not really the topic of our meeting here, but it is important that we say a few words about it when we are discussing data protection. Section 1 of LGPD states that the law is about data contained in any media, not only digital media. We know that most data today are stored in digital media. However, there are data that are not personal data. There are cybersecurity incidents that do not refer to personal data, that are extremely relevant, but that are not within the scope of LGPD. Also, there are personal data protection measures that are not relative to cybersecurity, but they aim at the mitigation of potential damages. We should treat as little data as possible, and therefore, in case there's an incident, the consequences will not be that severe. Also, account rendering in terms of security. That should come prior to operations, because the company should be able to demonstrate that all controls are effective and are in place. The major challenge to cybersecurity is adopting administrative and technical security measures that are enough and that are apt to data protection. This chain shows that security is like a chain that is as strong as its weakest link. Wherever there is vulnerability, that makes the whole chain vulnerable. So security models that are adopted should be in layers. Every security control is subject to failure, and that's why you need other layers to mitigate the effect of such incident. Ransomware incidents, for example. When the effects are very substantial, it's because the network was not fragmented. In case there is one incident, the whole network is affected. because there was no second layer after, for example, a firewall to stop the damages. Incidents will happen. It's all about knowing when. There are large IT companies that experience incidents also. So you will have to deal with them. It's all about being prepared and having the measures to do so. An incident is not limited to confidentiality breaches. An incident is something that compromises integrity, availability, and confidentiality of data. And there are two other filters to communicate incidents. First, it must relate to personal data, and it must be able to potentially cause damages or risk of damages, meaning that it is not every security incident that is within the scope of LGPD. The scope covers incidents that affect personal data, potentially bringing damages. So companies should be ready to map their risk matrix so that in case of an incident, you're able to say such and such data may have potentially been affected. Hence, this or that measure are appropriate. With outsourcing, something that we frequently deal with is the operator. So you should have an agreement with the operator that provides for their duty of communicating incidents. The operator is responsible for communicating, but the adequate communication flow sometimes is not in place. The most important thing about this slide is the purpose of Section 42. There I showed that the data owner. Section 48 determines that in case of an incident that can potentially cause damages, the data owner is the first one that should be informed so that they can take action and mitigate damages that can be caused. Also, because of the accountability principle, you also must take action to prevent so. What do I need in practical terms to address a security incident? First, I must be able to do so, and LGPD covers all kinds of agents because data treatment is something really pervasive, and we are talking about personal data of one person or millions of people whose personal data are under the coverage of a multinational company. So you must be able to stop to stop damage by being able to determine those that have been affected, whose data was affected. So you need access records. If you don't have that, that's going to be very difficult because the prevention principle determines that in this case we should deal with the worst case scenario. you also need risk matrix analysis, because not every incident is going to be relevant. Those who are able to determine if an incident is relevant or not is the one in control, is the controller. If you inform that an incident happened, but that you are not able to determine if it is potentially, it will potentially bring damages, you will have to assume the worst case scenario and take action to protect the data owners. It's very complex, and everything should happen within that reasonable timeline. Today, we are working with 48 hours, ideally. This chart shows the volume of incidents that have been communicated until June 2022. 321 incidents have been communicated. In almost 10%, we issued a notice. So there was some kind of potential damage, and that we had to send notice to the operators. The most frequent incidents were, number one, ransomware. Ransomware first, and then also broken access control, because companies have APIs that allow for data recovering with inadequate access records. So some malware can capture part of the data or all the data. It's happened more than once. More than once. Companies say, I do not have that kind of control, so I just can't say, I just don't know the users that were affected. The third kind of incident that's very often is unintentional disclosure. So if you have a very skilled team, very strong mechanisms, but if you have incidents that happen as a result of human error, you put everything at risk. Finally, the incidents that have not been communicated, because the law determines that the incidents should be communicated, but the agency can't be passively operating all the time. So we work to investigate ransomware groups, and we also have this procedure. And this is how we investigate the incidents, and we require the companies to communicate the incidents. This is not such a friendly, easy procedure, because there is an easier method. But in case it is not observed, this is what we have to resort to. Those were my considerations. Thank you very much.
Thank you, Bruno. Wonderful. Right on time. Let's hand it over to Rafaela now.
Que vai conversar com a gente sobre como aplicar e se resguardar e se preparar para quando, né, Bruno, o incidente ocorrer.
We're preparing for the incident, right? Thank you, Renata. And thank you, Bruno. Thank you for inviting me to this panel. And good afternoon, everyone. I am very happy to be here with you to talk about this very significant topic. I'm Rafaela Câmara. I work for the cybersecurity area of iFood. And I'm going to be talking about cybersecurity and incident prevention. You can see that the government is here. So I'm going to talk about this very objectively, very practically speaking. We're going to be talking about the law. So I brought you some experiences about what we do day to day in our company. Just a little bit of background about iFood. This is a Brazilian company. It's a food delivery company that connects deliverers, restaurants, markets, and customers. Most recently, this data was published on our site. We have about 60 million orders per month. It's a massive operation. It's a lot of data that we're working with, and we always need to be cognizant of what we're dealing with. We have different people. We have different players here. We've got customers, customer representatives, restaurant representatives, restaurants. It's a very complete ecosystem, and we also have a lot of employees. We have about 5,000 employees, I think. That was the last time I checked. 200,000 active delivery persons, and about 4,000 partners. That's markets and companies and restaurants. So I invite you to check out our portal. We publish this for civil society, for government entities, for people who are interested in what privacy means for iFood. We use 4 pillars that are very important for us: transparency, security, which we're talking about today, innovation, and personalization. All of this is part of our DNA. We understand delivery, and we want people to be the owners of their own data. Okay, so we're very careful with the data that we collect. We're very careful that we maintain privacy at all times. Okay, so we're talking about intellectual property today. I actually worked for years in intellectual property for iFood, but with such demand, we're now focused on LGPD. But I'm going to talk a little about the concepts that we focus on every day. The data protection law in Brazil, the LGPD, ensures the right to privacy and personal data protection. This is in the Constitution. There's a federal law. What does this mean? It means that individuals have the right to be the owners of their own personal data. This is the data that they can identify. They're identifying data. Sometimes it's very obvious things like your general ID number. Sometimes it's man, woman. So it can be anything. We understand that there's a data cycle, there's a collection moment, there's data sharing. Anything that may be related to this personal data in any form. It can be physical, it can be online. All of this is encompassed in this law and in this applicability. We have a number of different players here. We have the controller and the operator. They decide how this data is going to be handled. We have the data owner. When you talk about data ownership here, this is the person whose data we're referring to. We've got the National Government Authority. That's the National Data Protection Authority. And we have the person who's in charge of this, who holds the data. We call them the DPOs. One of the pillars of the data protection law is the pillar of security, as Bruno already mentioned. As a result, we need to implement technical and administrative measures to protect this data. And it is our legal right to recognize any illegal use or misuse of this data, loss of this data, misuse of this data, illegal use of this data. That is our duty as an operator, as people who use this data. We have a whole ecosystem. We've got preventive measures in this ecosystem, which we can implement now. What can we do right now to prevent incidents so that we can operate with a safe operating base? But we also have to think about what happens in the case of an incident. And this happens. We hope it never happens, but it does. Sometimes it's inevitable. This is also a window of opportunity. When we have an incident, the company can learn and correct and implement and remedy the situation. It's very important for a company to understand what preventive measures apply to that activities. There's no specific law. There are some very obvious preventive measures that are widely practiced, and some that are very specific to each company. So first thing we do is we assess the adequate measures that need to be taken for each specific activity. You need to be aware of what state-of-the-art is, what is happening, what's best for this context, and we need to register these measures. All of this is part of accountability. All this we also need to pay attention. They've asked me before, people have asked me, if I don't implement any preventive measures, what happens? No one will find out, so no big deal, right? No, but that's not how it works. If you don't have preventive measures to deal with potential damage, you're going to face irreparable damage. So we can really monitor and we can prevent any drastic incidents. The LGBT data protection law doesn't say exactly what preventive measures we need to take, but there are some good examples out there of what we do and what can be done. These are some of the ones that we implement in iFood. It's very important to analyze maturity in terms of security. We have an information security team. They analyze what applies to each case. It's very important to protect physical settings and technological settings and all of our spaces where we operate, where we work. So you need to protect computers and everything. You can't have just your password up on a little Post-it note, right? Training is very important. Sometimes very simple activities can lead to an incident. So people need to be aware, people need to be trained to recognize and prevent any incidents. We need policies and guides, very objective policies and guidance. This is the recommended measure, this is what you should do in this case, so that we can properly implement these policies. Just before the panel, I was talking to my colleagues, is that we were talking about incident simulation. This is something that we do. We look at possible incidents that could happen, look at a possible crisis, and we simulate what we could do if that were to happen. So we carry out these occasional simulations. It's important to understand what to do, what not to do, and to learn from these simulations, these non-real experiences, so that in the case of a real experience, we're ready. Incident detection mechanisms. So if I have a mechanism for detection, I'll better be able to respond to it. We also have to have a plan, a response plan, because when everything happens, when I'm all stressed out because all of a sudden we've got an incident, I need to have this plan in place so I don't have to make decisions. The more detailed, the better. And then controls, access controls, who has access to what information. All of this applied together ensures that you have a safe and prepared work setting. Now, talking about implementing controls, we need to understand what these controls are. When we talk about data architecture, we want to favor the user. We want this to be very user-centric. We understand that the data owner, the person, the user, is the most important. There are technical measures, safety, security measures, and equilibrium. You need to find a balance. You want the benefits both for the data owner and you want to understand the potential risks, and you need to have supervision or oversight. That's privacy policies, you need to do reinforcements. This is called privacy by design, and I'll talk a little bit about that in a few slides. So it's all for naught if you just implement and then don't follow through on it. You have to have something that's constant, updated, reviewed, and monitored at all times. So we look at these every single week. I refer to these every single week. Whenever we have a project or a project or a product, it's not just one. We look to minimize the amount of data. The less data we have, the less possibility we have for damage or security breaches. But we also need to work with data, right? So we always look at what's the minimum data necessary to reach our goal, our objective for that product or for that process. And can we use anonymous data? That's always important. We always ask these questions before we design or even launch a product. Here we have preventive measures for privacy by design. Anything that's a new activity in the company follows these steps. How can I implement privacy right from conception? I need to be proactive, not reactive, and I need to be preventive and not corrective. Privacy should be a standard, should be privacy by default. Privacy should be embedded into the design. I need positive sum, not zero sum. Privacy adds, it sums, it adds to what we're doing. It doesn't take away from it. Everything needs to work together. End-to-end security is also very important, and that's also part of the 7 basic principles of privacy by design, and includes full life cycle protection. Keeping things open, visibility and transparency are of critical importance. And finally, step 7, we have to keep in mind that everything should be kept user-centric. Okay, incident. What happens when we have an incident? What do we do when we have a data breach? We've got some initial actions right off the bat, monitoring. We've got team and people that are full-time looking at activities to make sure that there is no data breach. And if there is, they can act quickly. We have controls. We've got a response plan. That first hour is called the golden hour. It's absolutely critical. It is now when we can remedy the situation best. The first things we do are the most critical. We can stem the flood. We have to have a crisis committee and the person who's in charge of personal data, as well as 24/7 monitoring of activities and systems, and then we'll be able to stem the flood. If we have as part of our plan of actions, we have to have the investigation. We have to review the severity. We have to understand whether it was an accident or intentional. We need to register this. Everything needs to be registered. Everything happens very quickly. So people need to be prepared, and your technical teams need to be on the ready to be able to respond very quickly to any incidents. The severity, as I mentioned earlier, you need to know if it involves personal data. It could involve a crime. It could involve malfeasance. Again, does it involve personal data? That's where privacy comes in. Bruno mentioned this. Security doesn't always involve personal data, so we need to understand if there's the risk of personal data breach or not. I think if there's personal data involved in the incident, we have to assess the risk or the relevant damage, how significant the damage was to the data owner. We don't have very specific regulation in this regard. We have basically a guidance. So if there is any damage that we've identified, it's very important that this be communicated. You have to tell the people who were involved, people whose data was affected, and you have to tell the authorities. We have 2 business days. The recommendation is that this be communicated within 2 business days. Talking about incidents, there's the opportunity also to learn from any incidents. What are the lessons that we learn from any breach? And it's always important that we ask these questions so that incidents become opportunities for us to learn and improve. Thank you very much.
Obrigada.
Thank
Eu
you
vou
so
abrir
much.
para perguntas, mas antes eu
like to
vou
open up for
aproveitar a minha posição aqui
But I'd like
para
to
pedir
take the
a Rafaela
opportunity
que
to
conte
ask
para a gente um
Rafaela
pouquinho como
to tell
funciona
us a little
esses,
bit about
entre aspas,
how
treinamentos
these
que
trainings
vocês fazem
are carried
para
out.
tentar fazer com que todo mundo esteja na mesma página
Do you want everyone
para
on the same
quando
page all the
isso
time?
acontecer.
How do you do this? How do you make sure that you have very successful training for data protection? Case studies. Someone talks about a potential case or an incident and looks at the different possible actions that can be taken. A committee is called to participate in the simulation, and nobody knows if it's real or not. And nobody's familiar with the incident. And we ask them, what would you do in this case? We have the main areas, the main business departments that are involved obviously come. That's a technical team, information security and technology, IT, privacy, communications, and occasionally other business departments that may be affected are also, or impacted, are also invited to partake in the simulations. So we have different modules, basically. I didn't bring a case to share with you, unfortunately. So first step, we give them X amount of information. We debate it. Each department talks about the actions that they're going to take to mitigate the situation or to deal with the situation. We then go to the next stage. In the next stage, we offer more information because we've got more information for them. So here's something new. But that's exactly how it happens in real life. Information comes in bits and pieces as we investigate or as we get outside information. The case evolves and we get more information. And then in the third stage, we look at these information, we've got this other information, this is what came in, now what do we do? I was talking to Bruno. Right off the bat, it's difficult to know what to do. We don't have all the information. First off, we need to be as proactive and preventive as possible. And then after that, we'll be able to figure out, is this a media case? Is this a personal case? How do we communicate this information? So basically, we work with cases, and we learn how to be assertive when communicating. So there are these usually 3 stages when we do these simulations. In a plan of action, understanding the sequence of events and terms are very important. How often should you be reporting this? Is it every hour you need to release a report or information? Or is it every 2 hours? So all of this is very important. All of this is very critical in that first hour. That first hour is crucial. That's the golden hour. But those first 24 hours are also very important because that's usually when we're getting a lot of the information and
Maravilha.
we're able to investigate deeply. Thank you so much to the panel. This is for Bruno, but anyone can comment. I liked what Rafaela was saying. Those first few hours, if the company's trying to figure out what happened. So if you have this preventive measures and even if you have that, it's still a challenge. I'd say first 48 hours are absolutely critical for getting the minimum information necessary or as detailed as necessary to be able to communicate. Now, the company wants to communicate what happened because they want to show that they're transparent. So what's the best thing to do? Is it best to communicate preliminary and kind of almost early on, even without all the information, or is it better to wait a little bit once you've got more information, but then you might have lost this window? So when exactly is the best point to communicate? I'd also like to know about some of the other authorities. When should the other organs be communicated, be told about these events? Thank you so much for the question. In terms of the communication timelines, we've been discussing this extensively. The current rules have a guideline. It's not as robust as I would like, but it's very significant. And everyone has been contributing. Anyone can contribute, actually. Currently, we take our cue from the United Kingdom, and we look at different phases. So you can have a preliminary communication, and then you've got 30 days to complete the investigation and to report whether or not there was a data breach. So you've got this 30-day term, actually. This is considered quite an acceptable time frame. But there are situations where it's slightly different. Sometimes there's a data leak, there's a document leak, and sometimes it needs to be faster. And so we offer a little bit of flexibility. As long as you can justify this request for a longer time frame, a shorter time frame, we're fine. As long as you're showing that you're making the efforts necessary to get the information, it's okay. The other question was about other authorities. We have an internal system, especially when we have sanctions that that are applied, or there's a suspension, or any other sanction that has been applied. We work with the other authorities, so we send this information out. So we will publish this. And there was one, in fact, that involved Pix, which is almost like a Venmo here in Brazil, and we communicated this to the central bank because it affected them as well. Thank you. I'm Andrea. For a question for Rafaela. Your incident process is very complex and very well thought out. And you have to decide whether you're going to communicate, when you're going to communicate. And I'd like to congratulate you, but I'd like to know a little bit more about each of the separate steps. Our team starts, we do the investigation, and this is based on a couple of elements. We have a framework. We look at the volume of data, whether it was intentional or not intentional, if it involves sensitive data. So we basically have like a table, and we use this table to determine whether the risk was high risk, medium risk, low risk. Once we do a risk analysis, we draft a report which includes which are the most important measures from this point moving forward.
Alguma pergunta?
Any other questions?
No? Por favor.
I would just like to add to this for risk analysis. The company does need to do an impact report so that you have an idea of the risks that you're facing as a company. And this depends not just on the authority, but on the context. And if it's just people's names, you think that might not be a big deal, but it is. There are people that are in the witness protection program, and if this information gets out, this could be very detrimental. If you do some sort of program to minimize information, for example, payment, you can minimize the amount of information you're collecting or anonymize the information. Credit card. If this were to leak, What you do by minimizing the data, if you have a data minimization program or like anonymizer, you minimize the possibility of this leak being used for fraudulent transactions. So in the short term, when you've got all the stress and you've found that there's a data leak, if you've got these measures in place, you'll be able to decide whether you need to communicate or not, and what are the measures that need to be taken.
Nossa audiência que está online, da Daniele Campelo Tavares Gomes, do de Blas Parentes Associados, em que ela pergunta, com relação à definição da relevância do risco ou potencial dano do artigo 48 da LGPD, e conforme foi mencionado, a notificação não será para todos os incidentes. A ANPD regulamentará de forma mais objetiva o quesito da relevância para a determinação da real necessidade da notificação, tanto à ANPD quanto aos titulares?
So how do we determine how important the risk is so that we know who to report to?
Desafiadores,
This is very challenging. So we've discussed this. Keep in mind that, unlike the data protection law, there are two criteria, one for communication for authorities, reporting to authorities for risks, and one is for reporting to the data holders or the users. The data law has just one criteria, and we need to discuss this. We need to discuss which is more important, which is more prevalent. If we have a single criteria, we can either any risk incident to be communicated to the data holders, or we can determine that certain breaches should not necessarily be communicated or not communicated right away. One of the objectives of the law is to clarify what is considered a risk or what is considered damage for the purposes of communication as regulated. Again, I'd like to invite all of you, society at large, to take part and to share their opinions, because we're looking at how to improve this law or clarify this in the law.
Você já respondeu, que era
You answered the second part of her question.
GDPR, né? Enfim. Alguém tem mais alguma pergunta?
Are there any other questions in the audience here?
Acho que não. Então, antes de encerrar, eu vou convidar a todos que participem da reunião da Comissão de Direito Digital, que vai tratar sobre a consulta pública que o Bruno mencionou, e a oportunidade da gente, enquanto sociedade civil, se manifestar e apresentar nossas ponderações, que vai acontecer no dia 25, então todos os associados são convidados e bem-vindos para essa discussão. Então, queria agradecer.
Participants are invited to take part. Rafaela, Bruno, thank you so much.
Obrigada.
And thank you to our audience as well.